Thank you so much to everyone who joined us this evening in person and online. We know that this is an incredibly hectic and heavy time, and we're so grateful that you felt moved to carve out some time today to join us and discuss what we think is an incredibly pressing, important, and timely topic looking at anti-trans legislation in the United States today. Before we begin, we just want to acknowledge the solidarity action that is happening at Columbia University with the Students for Justice in Palestine and Jewish Voice for Peace Columbia chapter, who have been banned from holding actions at Columbia. Queer Caucus, as we have put out before, is fully in favor of a ceasefire, and even though we're here at this event today, we stand with all of the students who are protesting the ban of SJP and JVP. We are so grateful and honored to be joined by two expert speakers today. Milo Engelhardt, who is a staff attorney at the Transgender Law Center, and Dr. Christine Ryan, the Director for Reproductive Rights at the Law, Rights, and Religion Project at Columbia Law School. I'll leave each of them to share a little bit more about their organizations when they speak with us. And if you have any questions for them, which I'm sure you will, please just save those for the end. We will have plenty of time for a Q&A, and that goes to anyone who's joining us online, either on Facebook Live or YouTube as well. We'll be monitoring those comments, and we'll be happy to bring them to our speakers. Before we turn this over to Mr. Engelhardt and Dr. Ryan, I want to invite up my Queer Caucus co-chair, Eric Busby, who will share a little bit about the Center for Community Engagement and Social Justice, who is one of our sponsors for the event tonight. Thank you so much.
Hey y'all, thanks for being here. To those of you in the room, thank you both for joining us, and to those of us who are joining online. I'll be super brief. I am one of the co-chairs of the Queer Caucus, and I'm also an intern, a student worker at the Center for Community Engagement and Social Justice, and our sort of overarching umbrella theme this year is faith in democracy. We are aware that right now and that the political landscape has changed drastically in the last 5 years, and there was these sort of heightened, like, boiling points that have erupted recently, and we are prepared to see that happen again as we approach an election year. And so we're really focused on the intersection between faith in the institution and its role in preserving and protecting democracy. So of course, a forum on anti-trans legislation is and a way for us as students of religion to learn how our congregations, our chaplaincy, and our activism can join to be educated on trans rights and trans legislation, as well as how to move forward, how to understand, how to look at, and how to learn about what's happening in the legislative landscape today in America is crucial. So with that, I'll turn it over to our wonderful guests, and I'm thankful for our director, Reverend Fred Davey, for agreeing to co-sponsor this event.
Thank you, Eric and Brendan, and all of the organizations for bringing us to campus today. I have a slideshow, so you don't have to just look at me the entire time. And I'll be speaking about anti-trans legislation and responses to it from trans orgs and community, and a little bit of what we have to look forward to in the future. So we can just go to the next slide. Let's see. So today I'll just go through what TLC is, the organization that I'm at, what's going on with this massive wave of anti-trans legislation. Sorry. Yes. Yeah, maybe that's easier, because now I'm realizing I can't see my own slides.
Testing, yeah. Here, you
Okay.
can.
Thank you.
Creature.
Oh God, I feel very unprepared for that. Yeah, so talking about what's going on with the surge of anti-trans legislation, how trans organizations, communities, and allies have responded. I'm going to go over a case that I'm working on in Texas right now as sort of a case study in one kind of response, legal response, and do a little bit of legal claims and hopefully not get too in the weeds. So to start, the Transgender Law Center is the largest national trans-led organization working for a world in which all people are free to define themselves and their futures. We are grounded in legal expertise and committed to racial justice and employ a variety of community-driven strategies to keep trans and gender nonconforming people alive, thriving, and fighting for liberation. And to do that work, we're sort of broadly divided into two parts. We've got our programs team and we've got our legal team. The programs team is organizing and policy staff. There are a bunch of different projects like Positively Trans, which works with trans people living with HIV, or Black Trans Circles, which organizes this community building with Black trans people in the South. So they do all kinds of wonderful programs. And then we have the legal department, which has our legal services project, which runs the prison mail program, a help desk, and we have a Border Butterflies project, which works with trans people crossing the border, the southern border. It's based in Tijuana and San Diego. And then impact litigation, which is what I work in, trying to bring lawsuits to hopefully change some laws and policies. And all of our work is really grounded in the Trans Agenda for Liberation, which you can find on our website. It's this wonderful platform that tries to sort of lay out a vision for what like liberation can look like. And I think that's sort of key to TLC's work. We don't just try to be responsive to all of the bad things, but really try to focus on what building a better world can look like. But speaking of the bad things, the last 3 or 4 years have really been an unprecedented time in terms of legal attacks on trans communities. Before 2021, frankly, there was just less visibility, and so fewer attacks. If you think back to the 2016 North Carolina bathroom ban, it caused national backlash. Major sports teams, artists, and companies started boycotting the state. And because it was sort of singular, I think it was easier to coordinate that kind of response. But since then, there have been these new well-funded campaigns by right-wing actors that are pushing sort of cookie-cutter bills in state legislatures. And they're mainly targeting trans youth and using sort of the typical like protect children, protect the family framing that we've seen in so many previous homophobic attacks in the past. The numbers are pretty wild. In 2020, frankly, organizations weren't particularly tracking the number of bills proposed, and only 4 were enacted. But in 2021, it went up to 119 proposed, 17 passed. Then 2022, up to 174 with 26 passed. And this year, there were 586 proposed and 85 passed. So this year was kind of an explosion, just in terms of, yeah, these things coming to the forefront. And that's not to say that there wasn't like anti-trans violence happening before 2021. Obviously, there was. But just to see it become a priority for state legislatures is kind of a new phenomenon for us. So the people who are sort of spreading out these cookie cutter bills to all of the state houses are anti-trans activists on the far right, who now have sort of been mainstreamed in a lot of the Republican Party. The Alliance Defending Freedom is a major conservative legal org that we often litigate against. And then you've got right-wing think tanks like the Heritage Foundation, Manhattan Institute, and Family Research Council, many of whom were active in pushes against same-sex marriage and now have sort of shifted on over. And they kind of peddle the junk science that is behind a lot of these things, especially around like healthcare, where you have like the whole medical establishment basically agreeing that trans people deserve healthcare. And then you'll have like people in these right-wing think tanks being brought out as experts to say otherwise. Yeah, so there's been a concerted push by right-wing orgs, especially to leverage trans people, and particularly young trans people, as a divisive social issue to sort of fire up the base. And there have been interviews where some leaders, usually not one of the more mainstream ones because they're a little smarter, but other people have sort of admitted that like trans youth are like a more acceptable inroad to broader LGBTQ rights attacks. And Dr. Ryan will be able to explain much more about the religious rights strategy here. To give a broad overview of the sort of categories of anti-trans laws, I have this wonderful infographic from the Trans Week project by Raquel Willis and Chase Strangio. And it maps out 6 sort of different kinds of bills that have been pushed. There are the healthcare bans that I've already briefly mentioned, and I'm going to do a little case study on them later, but basically they usually focus on not allowing young trans people to access healthcare, but can also now are sort of spreading up to not allowing trans adults healthcare. There are bathroom bans, so not allowing trans people to use public restrooms that are most in alignment with their identity, which I think can often be misunderstood as a sort of minor thing, but if you can't use the restroom, you can't access public space, so you're sort of locked out of your community at large. There are sports bans, usually banning trans girls from participating in sports. Curriculum bans, which often go hand in glove with racist bans on teaching about the history of people of color in this country or institutional oppression. There are drag bans, which usually focus on LGBTQ community spaces, categorizing them as, it varies, but sort of basically trying to put them in the same category as like sex work adjacent things, and then like regulating them or just banning them entirely. And there are forced outing bills, which are usually aimed at young people in schools. If they share their identity with teachers or staff, the staff will be legally required to tell their parents, which can be extremely unsafe for young people. Yes, going on. So there is this sort of unprecedented attack, but there's also been a really powerful response by trans people, organizations, and allies. In every state, there's been a response to these bills. There's been protests at state houses. That's a picture from the Trans Education Network of Texas, which did an amazing job mobilizing people, so many that they shut down the public hearings at the state house because there were too many people on the list. And local organizations have really led these fights and really pushed to stop this transphobic legislation in their states. And in part because of this, 86% of anti-trans bills were not enacted into law. So I know the numbers are very bleak, but also there are some victories. And 11 states and DC have also enacted SHIELD laws, which are in some ways similar to one's for reproductive rights. And they protect people from prosecution if they provided care, if they had care, things like that in their states. And LGBTQ orgs, like mine, have filed at least 20 lawsuits challenging these laws. So we're taking them up through the courts. I'm gonna, in particular, focus on healthcare bans, which is not to like sort of reduce trans issues to healthcare issues like so often happens. It's just that I'm working on one right now, so that's gonna be a case study. There were 133 proposed this year, 26 became law, 10 of them are being challenged, and 22 states are affected, which I think is around 36% of trans people are living in a state with a healthcare ban right now. And just to lay some groundwork, gender dysphoria is the psychological discomfort or distress experienced by some trans people due to incongruence between sex assigned at birth and gender identity. That's from the DSM-5. And gender-affirming care are the prevailing standards of care provided through the World Professional Association for Transgender Health and the Endocrine Society guidelines. Every major medical organization supports this care as safe, effective, and necessary, like the American Medical Association, American Academy of Pediatrics, and so on. Although the right wing is making their own, in my opinion, fake medical organizations to testify in court about it. But we can go on. So, in terms of healthcare bans, every federal district court has ruled against trans healthcare bans. And I think this is significant not only because it's a lot of victories so far, but also because these aren't just judges appointed by Democrats. And these are the people who actually hear the evidence. They hear testimony from medical providers, they hear testimony from trans people, from their families. And in every case, they've said this, this is necessary care. People deserve to be able to stay in their communities and be healthy and happy and safe. However, appealing up to the next level of the courts, at the circuit courts, 2 of the 3 of them have ruled in favor of the bans, which got rid of the protections that those district court cases won. I probably shouldn't go through the citations. It'd be too boring. But the 2 cases that were ruled against have now petitioned to the Supreme Court. So we will get to see what Brett Kavanaugh has to say about trans health. But yeah, here we are. And then to sort of ground this in some more context, I'm working on a case right now called Low v. Texas. It challenges SB 14, which is a ban on gender-affirming care for trans youth. It not only bans care for young people who might need it in the future, it also mandates that if you are already receiving care, you can no longer receive it, and it will strip the medical licenses of any provider who will follow the best standards of care in their field and provide such care. We filed on behalf of 5 really wonderful Texas families, parents who really love their kids, kids who are even at like a really young age want to fight for their community, 3 medical professionals who all want to fight for their patients, and 2 organizations representing one, the Gay and Lesbian Medical Association, GLAMA, which represents doctors, many of whom provide this care, and PFLAG, to sort of have an organizational plaintiff. The families are all suing under pseudonyms. They all have, so Lowe is Lazaro Lowe, we have Mary Moe, they're all O families. And this is because of the sort of broad attacks in Texas, both from the state using the child welfare system to go after trans-friendly families and try to take away their kids, and because there have been a lot of threats of violence against parents who are supportive of their children and against trans organizers in Texas. Because of this violence, both from the state and from, in some cases, community members, some of the families have already fled Texas to go to states where their children can get the care that they need, which is, I mean, it's really heartbreaking, and we're seeing it not just for like our clients, but for people in all kinds of states, which is, I mean, it's making a parent decide between, their community, their job, their life in the state, and getting their kid health care. And like that's for parents who like do have the resources to move to another state, which is definitely not everyone. So we went to trial back in August, and the Texas District Court ruled in our favor. They entered an order blocking this law from going into effect. The state, through a specific Texas law, appealed directly to the Supreme Court, which accepted the appeal and allowed the law to go into effect. And we'll have a hearing in January before the Texas Supreme Court to try and challenge the law again. So I'm going to run through a few different legal theories we use to challenge these laws. One of them is equal protection based on sex. The 14th Amendment is the Equal Protection Clause, and past cases have established that if a state makes a distinction based on a person's sex, that's subject to like higher scrutiny because it might violate the 14th Amendment and deny a person equal protection of the laws. So these laws are sort of by nature based in sex distinctions. Using SB 14 as an example, it prohibits healthcare if it's provided for the purpose of transitioning a child's biological sex as determined by X, Y, and Z, really bioessentialist things, and affirming the child's perception of sex if that perception is inconsistent with the child's biological sex. So basically, you can provide the exact same healthcare for cis children as long as it's aligning with the sex stereotypes that the state supports. So things like top surgery for trans men or trans masculine people would be banned, but if a young cis boy has gynecomastia or something, then that would be allowed. And it's the same surgery. So because the distinction is entirely based on a person's sex assigned at birth and those sex stereotypes, we're arguing that this violates protections based on sex. There's also an argument that there's a sort of separate equal protection based on transgender status. And sex sort of established that it got a higher kind of scrutiny by establishing that it qualified as a suspect class. So in Brandt v. Rutledge, which was challenging the Arkansas ban, it sort of runs through the 4 criteria that courts use to decide if there's a suspect class. Historically subject to discrimination, there's a defining characteristic that doesn't bear on relation to contribute to society, ability to contribute to society. There are, it's a discrete group with immutable characteristics, and a minority group lacking political power. So trans people can easily be read into this. So we've also argued that like trans status itself, in addition to sex, should be protected. I probably should have gotten rid of this long quote, but basically in this analysis you have to weigh the state's interest in putting forth this law against the people's interest in being protected from discrimination. So that's where you want that heightened scrutiny, because then the state has to provide like a really compelling interest. It has to say, this is the only way we can achieve this interest, by discriminating based on sex or another category. And this is just a good quote which talks about how there is not actually a valid state interest in denying children care. The other sort of main argument that we're making has to do with rights of parents under the Constitution. So the substantive due process clause is the principle that the 5th and 14th Amendment sort of protect these fundamental rights like life, liberty, property, and that the government can't interfere with those in restrictions. And there's case law that says that the parent-child relationship can be the basis for a substantive due process claim, as there's a parental liberty interest in being able to raise your child within certain limits. So the state dictating that parents cannot provide their children safe, medically necessary care is a violation of those parents' rights and a violation of due process. That's the other sort of main argument we're making in our case and is made in several other cases. I think Dr. Ryan can really probably explain this best, but Dobbs vs. Jackson Women's Health Organization has been complicating some substantive due process claims because it says that fundamental rights need to be deeply rooted in the nation's history and tradition. And some courts are saying the founding fathers didn't care about trans children's health, which is true, and also like, so those more conservative readings are framing the right of parents very narrowly, and that's making those challenges more difficult. Looking ahead, there will likely continue to be a surge of terrible bills. The states have not lost an appetite for bringing these, and indeed are expanding, often targeting trans adults as well as trans children, and sort of using this as like a bully pulpit. We are going to the Supreme Court, which will be a big and impactful and complicated process, but we are going to continue to fight back. People on the local level are going to continue to engage in the political process. We're going to continue to invest in local trans orgs, provide legal support. The Trans Law Center has a gender affirming care legal defense fund that provides money for defense attorneys or whatever else is necessary if people are prosecuted under these laws. We're going to fight criminalization and support each other because many people are, living in communities where they're not supported, in schools, not able to get, the support and care that they need. So I think hopefully we can continue fighting together and finding ways to challenge these laws and also create supports outside of legal frameworks. So with that, I'm going to hand it over to Dr. Will. Thank you.
I may not need this. Great. Thanks so much for that, Milo, and thanks so much as well to the Transgender Law Centre for doing this impact litigation across the country. My name is Christine Ryan. I'm the Director of Reproductive Rights at the Law Rights Religion Project across the street at Columbia Law School. But in addition to reproductive rights, our work looks at how religion law can be used both to advance and erode equality across the spectrum, be it LGBT equality, reproductive rights, or broader progressive causes. And we look at how religion law is being used by some of the same regressive actors that Milo mentioned to strip freedoms, but also consider what a progressive blueprint for reproductive liberty could look like. And on both of these issues, I love working with folks like you who are a mixture of faith leaders, faith activists, theologians, students of religion, scholars of religion. And for that, I'm so grateful to be here. And I'm so grateful and honored to speak at this important time of Trans Remembrance Day. And I have to say that in my many years of practice as an international human rights lawyer and as a scholar and now working more domestically, the individuals who have inspired me the most and who consistently inspire me are people with trans status. And as soon as Milo mentioned that the Transgender Law Centre had a trans agenda for liberation, I was reminded that I really wanted to mention that, because for those of us who are cisgender, for people who have numerous identities, we get our best example of what it means to live your true self from trans activists and people living with trans status, in addition to seeing the level of resilience that is shown by trans people across the globe. So I'm really, really grateful to be here. So I've said a little bit about what we do across the street at the Law Rights Religion Project. So what I'm going to do is discuss some of the issues that Milo has mentioned from a religion law perspective, particularly trends in how religion-based claims are being used to undo trans equality in our federal courts. I'll do a deep dive into a case from this summer, known as Braidwood Management versus Clayton County. And if we have time, and hopefully maybe we'll get to it in more of a discussion Q&A type element of this session, consider how other constitutional arguments based in possibly the Establishment Clause or free exercise rights could serve rather than erode trans rights. So over the last 3 decades, gender identity, anti-discrimination protections, and other transgender supportive government policies have increased as government entities have sought to protect and support the transgender community. But of course, at the same time, in addition to the state legislation targeted at the transgender community that we've just heard about, litigation, particularly constitutional litigation and constitutional adjacent litigation by opponents of transgender equality, has proliferated. From those seeking to limit or eliminate trans protective measures. Their litigation has attacked everything from laws prohibiting anti-transgender employment discrimination to efforts of individual public school teachers to support transgender teens, to mandates requiring employers to cover healthcare for trans individuals in their insurance offerings. And regrettably, the religious right and the conservative legal movement have redefined religious liberty law over the decades in such a way that it's ripe for this moment when they are trying successfully at some level to undo trans rights. So recent victories for these anti-transgender litigators have included rulings that for-profit employers are prospectively immune from hiring workers of whom they disapprove for religious reasons, and that anti-discrimination laws are not neutral laws of general applicability for free exercise purposes. And to put these developments in a legal and historical context, you might be surprised to learn that religion-based claims for a right to discriminate, which is essentially what the conservative legal movement is creating, were originally characterized by the Supreme Court as patently frivolous. Their position back in the 70s was that discrimination simply lacked constitutional value and could not in any circumstance be the basis for First Amendment claims, that being free exercise of religion claims and also free speech claims. And this position nominally lasted to the end of the 1970s and the 1980s, though was not without exception, particularly with regard to employment by religious employers. Think of a church or a religious school or some other explicitly religious organization. But right to discriminate claims based on the Free Exercise Clause and the Religious Freedom Restoration Act, which I'll explain a little more in my remarks, became more cognizable to the courts in the 1990s. And as such, when the Supreme Court held in 2020, in the case of Bostock versus Clayton County, that anti-LGBT discrimination is sex discrimination, at least in the employment context, the conservative legal movement knew that they had a tool to chip away at that decision and this recognition of trans equality using religion law. That is, they knew that they could argue that compliance with laws preventing discrimination on the basis of sexual orientation and gender identity could require some employers to violate their conscience or their religious beliefs, would enable those employers to be exempt from the law banning discrimination on the basis of sexual orientation and gender identity. And that strategy, regrettably, is bearing fruit. This summer, on the June 20th, the Fifth Circuit Court of Appeals. Now, the Fifth Circuit is a court of appeals that you might have heard about in the past number of months for a range of bonkers decisions. But they issued a ruling in a case in which the owners of a Houston-based private for-profit company, they sought a ruling that federal anti-discrimination laws do not and cannot apply to them because of their religious beliefs that all people should be heterosexual and cisgender. And the Court of Appeals ruled in their favor, in an opinion that radically expands the scope of religious exemption law that had been created over the decades and undermines the power of federal anti-discrimination laws related to workplace discrimination. And this case is likely to go to the Supreme Court, so it's worth digging into it. And its recency and the importance of the context of employment also mean that this case deserves more attention than it has been receiving. So the case was bought by Braidwood Management. This company is wholly owned and run by a man named Stephen Holtz. He's a conservative, evangelical talk show host, conspiracy theorist, physician, and Republican megadonor who gained his wealth running a chain of health and wellness centers in Texas. Now, I really want to put that term in quote marks, and I encourage you all to look up just exactly what they pretend to do. He's filed several other lawsuits challenging the Affordable Care Act's mandate that employers include preventative care, including contraception or HIV prevention, medication in employee health bans, and even challenged early voting in Texas. So you can see what kind of background this company has. So Holtz employs approximately 70 people through Braidwood and says that he runs his corporations as a Christian business. He believes that homosexuality is a sin and does not permit Braidwood management to employ individuals who are gay, lesbian, questioning, or transgender. Essentially, those who engage in behavior that he believes is immoral. He does not permit his companies to recognize same-sex marriage or extend spousal benefits to an employee's same-sex spouse. According to Holtz, the plaintiff in this case, doing so would lend approval to homosexual behavior, make him complicit in sin, in violation of his sincere religious beliefs. And in 2018, Braidwood management filed a lawsuit claiming that the federal I work in reproductive rights, so when I see R, that's what I think of. The Federal Religious Freedom Restoration Act requires the government to exempt it from compliance with Title VII of the Civil Rights Act, which is essentially non-discrimination in employment. It extends to an employee's race, colour, religion, sex, or national origin. And this law is a federal law that has state counterparts, essentially, around the country, state analogues. And they prohibit the government from substantially burdening a person's exercise of religion, even if the burden results from a rule of general applicability, as opposed to a law that targets religion specifically. And to justify a burden on someone's religious exercise, the government must show that this burden is necessary to advance a compelling state interest. So as I mentioned in the Supreme Court decision of Bostock versus Clayton County, the Supreme Court held that Title VII's prohibition on discrimination on the basis of sex necessarily included protections against sexual orientation and gender identity discrimination. But Braidwood claims that because of the Religious Freedom Restoration Act, that their company should be exempt from the prohibition on discrimination because of the sincere religious beliefs of Stephen Holtz. Now, Stephen Holtz brought this decision before anybody tried to enforce it upon him or his company. This is known as a pre-enforcement action. And you might have heard of pre-enforcement actions because this summer in the Supreme Court case involving Laurie Smith, so it's the 303 creative case involving the website designer, she did a similar thing before anybody had even tried to hire her for her services or before the government of Colorado had tried to enforce its anti-discrimination law. Like Laurie Smith, Stephen Holtz brought a claim preemptively so that just in case down the line the Employment Equality Commission decided to enforce their law, that he would have this get-out-of-jail-free card. And what he's doing there, and similar to what Laurie Smith was doing, is to raise to them what seems like an important challenge to the national recognition that has been growing for the equality of LGBT people, in addition to the important legal consequences of these cases. So the three-judge panel of the Fifth Circuit, comprised of Reagan, Bush, and Trump appointees, upheld a lower court ruling that had been in Braidwood's favor. And the most important takeaways from this case include the following: that the federal courts are continuing to elevate the religious liberty rights of conservative Christians over all other regular laws. The opinion in Braidwood rests on the notion that religious liberty rights are a certain category of religious liberty rights for certain people, and Religious Freedom Restoration Act rights specifically, that they stand above and they supersede the normal operation of other laws. This trend and approach to religious liberty rights solidifies what we have seen in the past several years in the lower federal courts in terms of creating tiers of rights, which almost exclusively places the rights asserted by conservative Christians at the top of a hierarchy of fundamental rights. This case also portends the weakening of important federal anti-discrimination law protections. At the same time that the opinion elevates religious rights over those created by other regular laws, such as anti-discrimination laws, it really downgrades the importance of federal anti-discrimination law and the government's obligation to enforce anti-discrimination protections. It also dismisses the authority of the federal agency charged with enforcing Title VII, the EEOC, in getting at yet another goal of the conservative legal movement in deregulating their activities. Not only that, but in Braidwood, the Fifth Circuit took the radical step of discharging the Equal Opportunities Commission, Equal Employment Opportunities Commission, of any compelling interest in protecting employees against sexual orientation and gender identity discrimination. So what we have seen is a problem that is both top-down and bottom-up. The Supreme Court's conservative justices left breadcrumbs for lower court judges in Bostock in saying that in declining to rule on the question of whether religious objectors would be entitled to exemptions from complying with Title VII's prohibition of sexual orientation and discrimination. But in his dissent, Justice Kavanagh, here he is again, referenced the Religious Freedom Restoration Act, noting that it provided exemptions from federal laws that substantially burden the exercise of religion. And this was a signal to his compatriots, conservative religious liberty advocates, to pick up the issue and run with it. And now that's what they've done. So what we see in Braidwood, while it's just one decision, but it's representative of what lower courts are doing in picking up breadcrumbs left by the Supreme Court's right wing, when it can't get a majority to support what it wants to do, these extreme positions. And in this case, it left legal arguments and theories to be pushed by conservative lawyers. And because Dobbs has also been mentioned this evening, I think we can remember that this is precisely what Justice Clarence Thomas did in Dobbs when he signalled that contraception, same-sex marriage, anti-sodomy laws, substantive due process writ large could be the next right-wing issue that advocates should pursue, even though the majority opinion was clear that the Dobbs decision didn't reach those questions writ large when it overturned Roe v. Wade. As I said, this case is likely to end up in the Supreme Court, which will provide the right-wing justices on the court with an opportunity to further distort religious liberty doctrine and advance the cause of white Christian nationalism while undermining workplace equality rights without specifically having to overrule its precedent in Bostock, thus softening the landing of the decision. But there should be no question as to what in fact they are doing in creating that exemption to employment discrimination. If the Supreme Court affirms this decision and the Fifth Circuit's ruling in Bostock, it's unlikely that religious exemptions for private companies would be limited to discrimination based on sexual orientation and gender identity. And while that's the focus of the event this evening, we know that our rights writ large could be targeted. Private employers could also legally refuse to employ individuals who practice a faith different from their own, who are in interfaith marriages or interracial marriages, or who have had abortions. Remember, Stephen Holtz's issue was that he disapproved of prospective employees' behaviour. Nearly any law or policy, including those protecting crucial interests like workers' rights, public health, environmental welfare, or religious pluralism, may be significantly undermined by the Fifth Circuit's broad reading of the Religious Freedom Restoration Act. And this is something that the Law Rights Religion Project, as I said, we're across the street, come and see us, we try to emphasise so that we can engage the interests of a broad coalition. There's a serious risk in expanding religious exemptions, and we document the wide range of contexts in which religious exemptions have been made to stymie the enforcement of neutral, generally applicable laws. What is also troubling right now is that the courts appear, in many instances at the constitutional level, to defer to anti-trans parties' characterization of non-discrimination as imposing a substantive burden on their religious exercise. And again, that thus triggering strict scrutiny. So as Milo said, that means that the challenged law is presumptively invalid unless the government can demonstrate that the law is necessary to achieve a compelling government interest. So the threshold is high. One of the other things that we do at the Law Rights Religious Project is consider whether or not we can redefine and reclaim religious liberty rights. There are efforts throughout the country to do this in the reproductive rights context, in the context of other progressive social movements, such as the provision of humanitarian aid to migrants, the provision of safe drug spaces in cities across the country. The idea is that if religious liberty laws can be wielded to undercut government interests to such a broad extent, surely it cannot go one way. For if it does, that leads to the government favouring one form of religion over another, which is precluded under the Establishment Clause and the Free Exercise Clause. Which leads us to think about whether or not religion law can offer a way forward for trans equality. And I'll be honest, this is very nascent thinking. There are a small number of people who are considering this, but of course there is reticence and risk given how dangerous religion law has been for marginalized populations in this country. But we can still, and we still have a responsibility to think about it and use all the tools in our arsenal to fight against those who are weaponizing religious liberty law for their own purposes. We can think about whether or not the different forms of legislation targeting the transgender community, do they engender establishment law concerns? We ask, why does the state have dominion over the bodies of transgender people? Are the state legislators acting on the basis of pseudoscience that they believe in? Or are they imposing their power over our bodies on the basis of their own religious beliefs? And is this constitutional? And what about free exercise concerns? For those who have so successfully shown that their practice of religion has been burdened by employment, anti-discrimination laws, for laws requiring that you provide health care to your employees, why are we so complacent when there are people of faith who equally feel just as burdened by state laws that deny their children health care, be it reproductive health care or gender-affirming care? And again, these are questions that we need to ask, but as a lawyer, I need people like you to consider these, both those of you who work in the religious space and in the trans equality space, to think about responsible ways of doing this such that we do not create harmful precedents down the line. And that's why I'm so grateful to be here, both for tonight's audience and hopefully that this is the start of a continued conversation as we think about what tools we can use both for the decisions that we need to fight right now, but also for what will exist for the next 10 years. I'm reminded of a story that my supervisor, Professor Catherine Franke, often tells, in that the day after the Obergefell decision, the Heritage Foundation held a convening where they said, we're going to give Obergefell the Roe treatment. We're going to do everything we can to legally chip away at these rights while also advancing a strategy to overturn it entirely. So progressives, whether they're working from the legal perspective, the religion perspective, the activist perspective, we need to have a two-tier strategy as well. We need to chip away at the gains that those who oppose our freedoms have wrought, and also consider a long-term strategy for what reclaiming and re-envisaging a new form of liberation can be, and how to enshrine that in law. Thanks so much for having me.
We'll now open up for questions, Q&A. We'll use the mic in the room primarily for our guests that are attending online. So we'll be walking the mic around for people that have questions, and then also Brendan's going to monitor questions from our online friends.
Thank you for your presentations, for your great presentations. I'm a third-year MDiv student, Caleb. How do the courts then determine a sincere religious belief? So the question you put forward at the end, to me, this isn't just a strategy for us in the religious space. This is these are our religious rights. It's not like a strategy. So how do the courts define it, and why are we left out if we don't have the right political views?
Should I answer right away, or do you want to take a group of questions? Or, okay, that's a really good question, and I totally agree with you first in terms of we're thinking about strategy, but the strategy is motivated by the fact that these are sincere beliefs on the behalf of whether it's parents trying to provide the best care to their children. Of course, that's if they're a person of faith, it makes total sense that that would be an important part of their religious practice. The same way in the reproductive rights space, so many people, even who are been working in religion law for years, think that religion law claims for reproductive freedom are somehow new or novel, whereas in fact they're not. But also, it shouldn't take much imagination to think about how reproductive freedom or freedom over your body writ large is an issue of your religious freedom. But then getting to what the crux of your question is, how are the courts adjudicating sincerity? And at present, the way the doctrine works is that proving sincerity isn't a huge burden for a plaintiff. The courts are pretty deferential to a claimant, and there are good reasons for them to be so. Even it's not necessarily the sincerity part that lands us in trouble in decisions like Braidwood, though you can, and I might get into it, think about why Stephen Hutz's claims are not beliefs are not that sincere. But in general, the courts have taken a position that what matters is an individual's feelings of sincerity in their beliefs, and that they're the best placed to assert that and place parameters around that, rather than the court, for example, comparing an individual's subjective beliefs with established religious doctrine. And the reason that even progressives should not want the court to deviate from that approach is, well, there are a number of reasons. One is that your beliefs can be sincere even if they do not align with the official doctrine of your faith community, and as such, there shouldn't be a place for courts to adjudicate whether or not, a dissenter is less sincere than the officials who are representing their church. In addition, it would raise, legal concerns in terms of the Establishment Clause, but in general would just be improper for the court to have to decide what is and isn't part of somebody's religious belief. So the burden isn't necessarily proving sincerity. You are supposed to have to show a substantial burden, and again, there's a lot of deference there. That doesn't mean that every claim should be advanced and that create an exemption, because the government does get to show that they have a compelling interest in whatever law it is. If we take anti-discrimination law as the example, the government does have a compelling interest, and that means that they are able to, if they show that whatever the law is, that it is necessary and sufficiently connected to that compelling interest, the law should not immediately be overturned, or an exemption should not be granted automatically. In part, in terms of progressive causes, you run up against issues around a lack of education among judges and even among lawyers. As I said, even though there have been free exercise claims made for reproductive rights since the 60s, people think they're brand new and they're suspicious of them. But really what that does is place the beliefs of some over the beliefs of others. And in part, this strategy is untested in many spheres. From my research, I could only find, one or two free exercise claims in favor of, litigated for same-sex marriage. And that's for same-sex marriage rather than seeking an exemption or trying to prevent its legality. So that's where we are, and that's why we're at the Law Rights Religion Project. We're curious about the strategy. We're interested in hearing from people who are, but while also will take a very cautious approach.
Hi, thank you both for being here. I think this question is for both. It's sort of a cluster more than a question, so bear with me. But I guess, first of all, I appreciated very much, Milo, what you said about like a bathroom ban isn't just a bathroom ban. It's about, can a person leave their house on a weekend and like expect to be able to stay out in the community and not have to come home? So like restrict their movement, right? And that applies to homeless people and tourists and not just trans people, right? Or the idea of discriminating against somebody for trans status in a job interview process seems pretty niche until you ask anyone, like, would they want to be applying for a job and have the hiring manager check their genital status as part of like whether they're competent or not? I think like anybody would probably say no, right? And so I guess like a couple things. One, how do we get people to get that this is not a niche issue, which is a really big question, because it's one that like, if I were not trans, I have been not trans. I haven't ever been not trans, but I didn't know I was trans before, and at that time, trans issues seemed to me like a niche issue, despite my politics of intersectionality and my belief that all struggles are connected, etc. Still felt niche to me, just honestly. And when it gets into legalese, it can feel really intimidating, far away, or hard to access or understand the entry point. And that's on purpose, I think. So I guess one of the questions is, seeing trans issues as the site of like a testing ground right now for how much the right can get away with, essentially, right? Starting with trans youth, because that's pretty, like, excuse this, but like low-hanging fruit, right? We're gonna see how much we can pass, what strategies we can do, and then like move on to other things. So in that way, I see this as very connected to other issues. Like we're saying with the religious stuff, if you can discriminate against somebody because of their gender identity, you can also you could hide anything under that, right? You could hide any identity within that, right? So that's scary. So I guess, how much do you see this as part of a larger coordinated strategy is one question. Another question is, what are some of these awful laws we can look forward to in 2024? What are some of the new categories you might see? And if you have ideas about how to make this kind of thing more accessible, or maybe just a broader commentary on how you do see this as connected to Black liberation, to what's happening in Gaza, to any other, issue of the day. Like, what is it that makes this not actually niche? That would be my comment and my question. Thank you.
Hello? Oh. Thank you for all of those good questions and thoughts. Yeah, that brings up a lot. To try and answer some of them, in terms of how to get people to not see this as like a niche issue and really recognize like the shared humanity of trans people, I think one thing that I think about with litigation is I think about it as an opportunity for storytelling, and like education, not just for like the judges who are, hoping will decide in our favor, but also thinking about how like news organizations pay attention when you file a case. And you often, you're telling a story of your client's experiences, what they're going through. Even with like anonymous plaintiffs, we can share what's sort of been publicly filed. So thinking about litigation not just as like what we win or lose, but cultural change as well. And we have a wonderful communications department that thinks about it broadly as well. And then the other thing that came to mind for thinking about this is not like a super niche issue, is just thinking about just how regressive these laws are for everyone. Because, on one hand, you've got these laws that are saying like, the medical community doesn't know what the best healthcare is. Like, Greg Abbott knows what the best healthcare is, and he does not have a medical degree or any training. So it's this weird like state supremacy and overreach in this way that should be concerning to everyone. And also it's like policing this binary in an incredibly narrow way that like should even concern cis people. It's saying like, cause a lot of like quote unquote gender affirming care for young children is just like letting them dress certain ways, try out certain pronouns. Like it's just letting kids sort of be free and experimental with their gender presentation, which is something that everyone should have the freedom to do. So I think that really all of our sort of liberty is implicated by these laws in really big ways that I hope can be understood beyond just affecting trans people. In terms of the terrible things to look forward to, I think the next sort of frontier is healthcare for trans adults. We're already seeing that in like Florida, where they were pushing people specifically on like state-funded health plans, but I think they're just sort of trying to like expand out further and further. But it's hard to say, yeah, I don't know. What do you think to all this?
Thanks very much for both the comment and question, and I was not organized enough to bring up a pen with me, so I was taking notes of your question on my phone. So one part of what you said was in relation to the coordinated strategy of right-wing actors, and for me, that's how I ended up focusing on essentially First Amendment issues, was because if you look at what the right has done over the years in, capturing that doctrine and free speech doctrine, I should say, to propel a whole range of regressive policies, from medical refusal of care to campaign finance to now undoing the real basis of anti-discrimination law in the employment context, really basic protections that we've had since the 60s. And everything they have done has been, they use the main organizations, the big ones, and Milo mentioned some of them, like the Alliance Defending Freedom. And they used to describe themselves almost, entirely in religious terms. But they got bolder and bolder, and they don't even bother trying to make religious claims when they're attacking, the participation of young people with trans status in sports anymore. They've created a whole parental rights department. And that is where I see a real, again, thinking about what they've done in religion law, and it is in the parental rights space. It's something that I'm trying to learn more about and consider more and think about what tools exist, because what that department is doing at ADF is trying to undo the whole public education system now, on using, this what seems like a niche legal theory. In no way am I saying there are debates that exist around, should groups like the Transgender Law Centre or the ACLU or the NCLR, they are critiquing, the parental rights frame. That's not what I'm saying at all, because I don't think we concede any legal arguments to right-wing actors. What we've to do is to keep a hold of them, such that their meaning can be construed in a progressive manner that favors the social issues that we all agree on. And that's difficult to do because we still don't know the law is changing so fast right now. And it's still different in different parts of the country, even federal law, because you have these circuit court splits that Milo mentioned. And we're not sure how everything will transpire, which is just to say that it is, there's a responsibility on, my centre, for example, to do more and more public education. And that's why I do try to engage with other disciplines and other actors as much as possible. But I also, I hope that groups who are active in this space won't feel that, because as you said, the legal issues can be dense and they're multi-layered, but don't shy away from getting involved, because fundamentally, these laws exist for everyone, not just for people who are educated as lawyers, and that your vision for what a right should mean is really important if we believe that, that type of vision that of the citizenry is what should be imprinted into our laws, rather than the views of a small minority of conservative Christians.
Any other questions in the room?
So one thing I've been thinking about a lot I think, what is the number now? Like over 580 anti-trans laws have been proposed this year. Obviously, only a fraction of those have actually been passed. And then many of those that have been passed are now being fought. But as a trans and non-binary person moving through this world, moving through this country, it is sometimes hard for me to find the line between what is an appropriate level of caution and concern and what is my own internal fear-mongering that is keeping me from existing fully in the world, which obviously introduces a lot of other complex issues about my own identities and the ways that I am privileged, versus discriminated against, marginalized by my trans status. And this actually came up. Dr. Ryan and I were talking earlier about how we're going to the American Academy of Religion this weekend in San Antonio, Texas. And a couple of months ago, I went to Milo and I said, is this a conference I can go to? Is this going to be safe for me? And it's that kind of thing where the mental weight of having to make that calculation of like, is this state safe for me to visit? Is this state safe for me to drive through? It can be hard for me to parse the reality for many or most trans and non-binary people from the intense level of scrutiny and fear that's building. So if either or both of you have thoughts on that, I know I would really appreciate it.
That is a very complex question. First of all, I was in San Antonio last weekend and I had a lovely time. So hopefully you will also have a lovely time. I think what you raised with like all of the other like biases that come into that is something that I come back to a lot, especially thinking about like so many of our clients in Texas, as like young trans people, we're living like relatively happy lives up until the state came and tried to take away their health care and divide their families. And I mean, there are trans people everywhere. Most of our programs team is in the South because that's where our particular focus is. And there are like powerful, thriving trans communities in every state. It is a really complicated question to figure out like what your own personal safety is, because I also don't want to like underplay the violence and be like trans people are safe everywhere. So I think just like, yeah, I mean, one thing that I do when I travel for these cases is try to like talk to people from the state and like be like, oh, like what's a nice like restaurant to go to or something, and just kind of like try to get a sense of like, where are like good or safe places, and to get a sense of like how trans people live in these spaces. It's tough, and I think ties into something that we're seeing a lot with like, especially people from states like New York, where we are sort of being like, why don't you all leave and like come to New York or come to California or something like that, which ignores so many other things, like really powerful, valid reasons people would want to be in other states, like family, community, history, culture. But that's getting a bit away from your question. I would say maybe talk to some trans Texans and find some fun things to do in San Antonio. And yeah, just follow your own instincts about comfort and safety, and hopefully have a good conference. I don't know, do you have any?
I mean, yeah, I'm obviously, I have a lot of privilege as a cisgender person. And I think that, I do want more people to be alarmed by what we're seeing in the courts, in particular, because it could get even worse. But with regards to, you living your daily life, I mean, you obviously, you're putting on events like this, you are active throughout union, you're at union. I think from our first conversation, you're going to be working as I could get the term wrong, but I'm going to say pastor soon. People like me have so much to learn from you. and it'll be the same in whatever scenario you're working in or existing in. So that is, and I wholeheartedly feel that. But don't feel like you have to put a ton of pressure yourself. If there's days where you need to curl up and be indoors on a couch with your cat, that's fine too. No.
Is there anyone else who has a question? I didn't see anything come through online, Brian.
Yeah, I don't know how to raise this issue without sounding defeatist, because I'm not. I'm very optimistic, actually, in the long run, and the work that you both are doing, and thank you so much for presenting, is going to be foundational in telling those stories, in crafting those legal arguments. But from my point of view, right, it seems likely that these arguments are going to appear in dissenting opinions before they appear in majority opinions, because we have justices who, for decades, have been selected explicitly on ideological and theological grounds. And that is going to take decades to change. And so I wonder if you can... Yeah, I don't know where the question is here either. Just a comment, really, I guess, that my tactical orientation is toward taking these stories, taking that reality that the civil rights era in the courts ended when Kennedy retired, and concentrating in the short term on political organizing, electing better candidates who will appoint better judges, maybe even reform, expand the court. Can you comment on the ways in which your organizations are oriented to that side of our strategy as well?
Yeah, that is something that, we think about a lot at TLC. It is a very bad time to be a trans rights litigator in some ways. And also I don't know, I feel very, very grateful to get to do the work that I do. I was at a convening a few weeks ago where Miss Major was there. And for folks who don't know, Miss Major was present at the Stonewall Rebellion and is this incredible trans activist who's been active for over 50 years. She currently runs this retreat for trans women in Arkansas, and yeah, she's amazing. And it was a convening of trans rights litigators, and she spoke with us and she was like, here I am again. But I think hearing her talk about how she's been struggling for literally half a century for trans rights and all of the changes that she's seen really helps me take a longer view about this community and so many communities that are going to be affected by this horrible court have survived through so much for so many years. And so I think thinking about the power and resilience of those communities is something that gives me hope. So thinking in the very long term is one thing that I try to do. And then I also try to think about what can be done in the short term, not just how can we win at the Supreme Court, which seems difficult, but also when TLC saw all these bills being passed, we worked with a Repro Legal Defense Fund to create a gender affirming care legal defense fund, or what did we call it? I forget. But it's not just for gender affirming care, it's broader than that. So thinking about how to get people resources to fight bad laws, thinking about what we can do in states where we do have power, like all the states that have these sort of safe haven laws, like New York, So trying to think both really pragmatically, like what we can do in our space with the power that we do have, and also being like, this is a very long, like, fight, and hopefully, I mean, Miss Major did say that she didn't want to be here again, specifically on that couch talking about the same issues, but she did say that there was a lot of like hope that she had for the future, and if she's been doing this work for 50 years and still is full of hope, then I feel like I really need to cultivate my own hope, try and emulate her. But
Thank you. You know, I don't think that I can put it better than Milo just did in terms of, you know, take incremental steps right now to gain inroads and to reclaim space that has been taken away from social justice issues, but also I think learn as much as we can from other movements, and maybe even other countries, which legally isn't as useful a strategy, but in terms of organizing and vision and hope, it certainly can be. And, you know, when I first moved to the US, you know, as I said, my background is mostly, but not entirely, reproductive rights. Ireland had the most restrictive abortion ban in the world. And within 3 years of my arrival, we had overturned the constitutional provision that established a right to life for the unborn and, you know, created complete criminalization. That was a long fight by people who couldn't have imagined in their lifetime that over 2/3 of the population would have voted for a liberal abortion rights regime in the country that would be provided in the public healthcare system for free. And so sometimes I try and remember that. I think about how we have so much to learn from groups who have seen essentially little success in their lifetimes, and there I think about the Indigenous rights community and how both, you know, their battles, even the tools they're using, have to be deeply structurally flawed because that, you know, the Constitution was created on the backs of their suffering. But you did point to as well having to think about broader structural ideas, you know, in terms of reforming the courts. So trying to keep our minds open to whether it's legislative strategies, judicial strategies, faith-based strategies, is essentially all we can do right now, both taking small steps and thinking about what a longer term form of liberation looks like. And again, what did you call it? The trans agenda for liberation? I mean, that's probably something that needs to be printed off and put above my laptop for me to look at and think about what a different type of life and world looks like. So that's where I get my inspiration anyway.
Thank you so much for that. Is there anyone else who'd like to squeeze in a question before we close here? Okay. Well, thank you all again for coming to this forum on anti-trans legislation, especially during such a busy time when there is so much else you could be putting your time and energy towards. There are, as you probably saw, some food and beverages in the back for you. Please help yourself and linger as long as you'd like. And we will be sending out the recording of this event to our Queer Caucus mailing list. So if you're not on that and you would like to be, let me know. And we are just so appreciative to Milo Engelhardt and Dr. Christine Ryan. Thank you so much.